legs.
9?
9, 10, 11.
Okay, what are the matters? Any other?
Yes, Lordship. With regards to part 2, item number 12, may this matter kindly be taken up next week, Lordship.
All right. Yes, upgrade those items.
18.6, item 12. Daily list for orders, item 9.
Other side is.
May it pleases your lordship.
Oh, yes, you're there. Yes, what was this?
Now, my lord, may kindly come. I'll take your lordship straight away to the ground which I am agitating in the present rate, bail application. My lord, may kindly come to page number 12, 1, 2.
Yes.
My lord, this is a notice under section 48 of the BNS Act. Now, this notice was never served to any of the family members. In fact, this notice is countersigned by the accused himself. It simply says there is no ground, nothing mentioned. It simply says that her grounds of arrest was informed to her mother, Neelam, phone number such and such. And this is a squarely covered case. It is only, my lord, 15 days back, this honorable court, same police station, same type of section 48 notice, this court has held that this will not suffice the requirement of article 22. I'm relying on that judgment, my lord. My friend is there. If your lordship kindly takes up the order dated 25/5/2026 passed in BA number 31/2026. BA number 31/2026 squarely covered matter. My lord, may kindly peruse para 6 to show the similarity of fact.
There's any other ground?
My lord, this is the sole ground I am agitating, and I am also relying on para 8, 12, para 8, 12, and para 18, the view of the court. In fact, the same issue was also dealt by this court. The same police station, same intimation of arrest, absolutely identical, my lord.
Yes.
And I'm also relying on another coordinate bench judgment, my lord, BA 20 of 2026. Here also similar thing, my lord. Nothing was communicated, only the accused countersigned, and some phone number was mentioned in the arrest, in the notice under 48. That is BA number 20 of 2026.
Yes.
Yes, Your
BA
Lordship,
number 20 of
admittedly,
2026.
Your Lordship, for ends of justice, admittedly, section 48 is not complied in spirit, in full and in spirit. So, Your Lordship, my only prayer is a stringent condition may be imposed on the fact that the applicant is not is a non-resident of Mizoram. And my second prayer is, Your Lordship, in another case, Your Lordship have mentioned that it's a high time that the SP concerned should be notified in this and should take necessary action. So,
Who should notify?
Your Lordship, maybe there should be some.
It's for you to take
order.
action.
Yes, Your Lordship.
You want to lean on the court to take action against the police?
Maybe a line or two in that regard, Your Lordship.
Okay, we'll pass orders. Yes, next.
I'm deeply obliged, my lord.
Item 10 must stand and 11.
Mr. Lordship, this is an application under Section of Limitation Act for condition of delay. in filing
89.
the 89 days, Your Lordship.
Yes, any objection?
No, Your Lordship.
Already heard learned counsel for the petition and learned so and so. On the decision, this IA has been preferred, seeking condonation of a delay of 89 days in preferring the connected appeal against the judgment in order dated 5/12/25 and sentence in order dated 8/12/25 passed by the learned special judge, PC Act, Mizoram, Aizawl, in SRPCA 04 of 2024. See in order dated 12/5/26 against the reasons for the delay has been explained at paragraph 2 of the instant application, wherefrom it appears that the applicant is a cancer patient and has been bedridden for quite some time, and as a result he could not take immediate steps for preferring the appeal. Para learned additional PP submits that prosecution has no objection to the condonation of the delay. Para, having regard to the above, I am of the view that the delay has been sufficiently explained. Accordingly, the same is condoned and the IA stands allowed and disposed of. Another, what is 11 with? It's a separate
The
item.
main appeal.
Okay, appeal is listed as a separate item.
Mr. Lordship, in the main appeal, this TCR may be called.
Any private respondent is there?
No, Your Lordship.
So you were convicted ultimately.
Yes, Your Lordship. But however, we are not present due to the condition of his health.
Already heard learned counsel for the appellant and learned and PP. This appeal is directed against the ordered judgment and so and so. Call for the records. You have been served copy?
Yes, Your Lordship.
For the TCL list the matter again on.
227.
Much obliged.
For admission, item number 2.
My Lord, this is a case where the respondent will not file affidavit in opposition within one year since filing said petition.
So
None
you
of
also
the
filed your reply after another 1 year.
none of
Yes,
the
Your Lordship, in
respondents
the
has-
last court date, I was instructed to gather the information regarding this present case. And Your Lordship, as per my information, the challenge which the petitioner had made, that is regarding the central scheme and the pay scale. And in that regard, Your Lordship, the information which I received is that it is stated that the state has the power to engage in their own terms. And not only that, Your Lordship, the pay scale which the central government had stated, in that pay scale, the required qualification was not attained by the petitioner.
Then you have to file the affidavit.
Yes, exactly, Your Lordship. You have to file the affidavit.
But
the proper
it's been quite some time. Now, since you have the instructions, you should not take more than 2 weeks.
Your Lordship, if at least if we can take 3 weeks, since there is some administrative procedure which has to be followed, the otherwise comment which the department has submitted has to be vetted by the law. And again, it has to go back to the concerned department, and later on we will receive the otherwise comment. So it takes time, Your Lordship.
Already heard learned counsel for petitioner. And so learned state council submits that instructions have been received, but some time is required to submit the affidavit incorporating the instructions. Accordingly, list the matter again just after 3 weeks, okay?
Deeply obliged.
37. Item 3.
Lordship, I'm appearing on behalf of respondent number 6. May I seek another 2 weeks' time for filing affidavit in opposition?
No objection.
Already heard learned counsel for the petitioner. So answer 6, 2 weeks time to file affidavit in opposition. List the matter again on.
29.6. Item 4.
Lordship, this is a very serious matter which happened in the state of Mizoram. My Lord, in the last occasion, last court, Lordship, Justice Michael directed and give chance that to withdraw their statement, otherwise will send to jail. So, my Lord, they file a short affidavit. My Lord, actually that he can explain the counsels for the private respondent. So I have lots to say. Actually, unfortunately, today I come prepared for disposal. But unfortunately, I have been informed this morning that the leading counsel for the government is unable to come today. So if
Meaning I can file the petition.
Where is the petitioner now? She has been evicted from her house.
Yes, of course, Lordship, with not only the petitioner, with all her family members also. But, my Lord, this is only the fourth prayer. We have another main, another prayers also, my Lord. We claim for compensation, and we claim for setting aside of the impugned police PR also, and also very importantly, we claim for registrations of the case against the culprit who burnt our houses, our property, our vehicles. And the court indicated that those matters will be taken up step by step, one by one.
So affidavit has been filed by 5/8.
5 and 8, 5 to 8.
5 to 8. Who are 5 to 8?
The private respondents,
Eh?
my Lord. Local council NGO.
Okay. To that you have filed any reply?
My Lord, I need to. Because, my Lord, the court indicated that earlier occasion to withdraw unconditionally, but that affidavit is what they reiterated in their counter affidavit.
What about the state any affidavit by the
They
state?
already filed, my Lord. They already filed. They justify their action again, which the court did not accept earlier occasion. And, my Lord, if you read very carefully, I did not find any kind of this thing withdrawal at all. The language itself, I read one by one. If you read Annexure 2 also, and they assume themselves that they have the power. If you read that, because they don't have the power at all. Allow me to read, my Lord, Annexure 2.
Just a moment, I am just trying to get a grip on the matter.
I can explain briefly.
No, the first part I have understood. You were evicted and then there was a press statement. So what is the relief you are seeking now?
One relief is that for registration of criminal case against all the culprit in view of the Supreme Court judgment in Tehsinlal. The Supreme Court is very clear that case should be registered, should be arrested. Those persons should be taken up by handled by special court. It is very clear by the Supreme Court. Should be disposed of within 3 months by the special court. That is my first prayer. Second is that for setting aside of the impugned PR, because it violates the Putusurami judgment passed by 9 judges bench right to privacy. And number 3 is that for claiming compensation, which they admitted, last occasion also the government admitted that they will pay. That 7,61,130.
So as far as pleadings are concerned, what remains? Your reply.
My Lord, if liberty may be given, reply to the affidavit in a short time.
All right, then let's have everything. Then we can. Go.
Because, my Lord,
we need a full-fledged hearing.
Definitely, definitely. That's why I come prepared since the government advocate is absent today. My Lord, their affidavit is that they stated that we make that affidavit, that eviction order, because that to pacify the people. Because what happened at 6 p.m. everything was already turned into ashes. They had a meeting at 9:30. Nothing remains. That is afterthought only after filing this case. Completely lie, completely false. They misguided the court.
Yes, you bring that up in your reply.
Definitely should.
Yes, Heart Learned Counsel for the petitioner, Learned Counsel appearing for the
And can we have next week?
respondents, as also Learned Counsel appearing for 5 to 8. You are for 5 to 8?
Yes, my Lord.
Yes. Learned Counsel for the petitioner prays for some time to file a reply to the affidavits filed by
Respondent 5 to 8.
5 to 8. Okay. Hence release the matter again on next week.
Next week, my Lord.
18.6.
Much obliged, Your Lordship.
Item 5.
Your Honours, I am appearing for the petitioners, Your Honours. I may be permitted to appear online, Your Honours.
Yes.
Your Honours, this is a GST matter wherein consolidated show cause notice for multiple tax periods has been issued and an order in original has been passed. These cases, Your Honours, these are pending before the Supreme Court also in special SLP number 18089 of 2026 as against the order of the Delhi High Court. And the Madras High Court and the Kerala High Court are in the favor of the assessee, stating that a single show cause notice, consolidated show cause notice for multiple tax periods cannot be issued. We have served the department also, Your Honors, in the last occasion through Dasti also, and the acknowledgement has also been submitted along with an affidavit.
All right, anybody appearing after Dusty service?
Lordship, I'm appearing on behalf of my senior Mr. Johnny L. Tautsong, Departmental Counsel for the CGST. We may need more time to obtain instruction from the department, my lord, to obtain parawise command and all.
Not just instructions, you have to file your affidavit. One date for instruction, another date for affidavit. What is that? Or do you don't intend to file affidavit? All right, you are protected for the time being, it appears.
Yes, Your Honors, that can be extended, Your Honors.
Third learned counsel for the petitioner, Mr. So-and-so through VC. Mr.
Lalmang Isanga, on behalf of my senior Lordship,
appears on behalf of
Johnny L.
who is,
Tautsong.
he is what CGSC?
He's the Departmental Counsel, Lordship,
The departmental counsel for
CGST.
department is not called GST,
Central GST, Your Honors.
central GST.
Yes, Your Honors.
It is submitted that further time is required to obtain instructions and file affidavit if deemed necessary. Accordingly, for the 4 weeks time is granted. Interim order passed earlier to continue till the next date of listing. List the matter again on
16-7.
Much obliged, Your Honors, much obliged.
Item 6.
Yes, Lordship, in this matter also, I'm appearing on behalf of my senior, and from the office note dated 10/6/2026, notice upon respondent number 3 is completed, and respondent number 2 is still awaited, my lord.
who is to
Respondent number 2 is Miss Srimati Tialuangi.
accused person,
Yes, Lordship, the accused.
acquitted.
Yes, Lordship, they are all acquitted in the CJM court.
From Sampai.
Yes, Lordship, Champai.
Was notice issued. (24/4). I think you'll have to take fresh steps because this was issued by speed post on 24/4/26. If it does not come back by now, it won't come.
Yes, Lordship. I will, by way of custody, I'll do by now.
I'd learned counsel for the petitioner. It appears as per office note, service on respondent number 3 is complete. However, none appears for respondent number 3. What about 1?
Lordship, respondent number 1 was already demised on 21/6/2021.
Huh?
He was already demised.
Oh,
Dead,
he expired.
Lordship. Yes, Lordship.
Respondent number 1 has already expired
21/6/2021.
on 21/6/26.
21/6/2021.
2021.
Yes, Lordship.
Oh, you have made
2020.
a dead person the respondent. His name be struck off from the list array of list of respondents. Notice on respondent number 2, sorry, notice on respondent number 2 is still awaited. It appears from the office note that notice was sent by speed post to respondent number 2 on 24/4/26. Hence, appellant is to take fresh steps for service of notice on respondent number 2. Place the matter again.
13/7.
TCR has been received.
Much obliged.
Item 7.
May I please, Your Lordship? Lordship, this is the first time it has been taken up, and we have parties appeal under Section 173 of the Motor Vehicles Act against the judgment and order 21/10/2025, passed in MSCT number 23 of 2023, where we were being directed to pay an amount of 29,66,000 with 7.
In the original MSC case, who are you?
We are the
Respondent number?
respondent.
You are Anil Sethi,
No, Lordship, we
Tongvunga,
are the company.
New India.
Respondent number 3, yes, Lordship.
Okay, so vehicle was insured.
Insured, but however, Lordship, in the police report, which is at Annexure 3, clearly shows that the accident was caused by rush and negligently. And also under Section 166, that is a fundamental right, the claimants have not proved one of the fundamental rights, that is the income of the deceased. We can clearly, it can clearly shows from the
No,
cross-examination.
rash and negligent act is there. That is why the award has been made. Otherwise, since the vehicle is insured, you are liable to pay. So your case is that the income has not been proved,
Yeah,
right?
income has not been proved, and that the police report income and the offending truck vehicle, that the negligence had not been proved by the claimants. That is two of our grounds. Because the income, it clearly shows that in the cross-examination of the claimant's witness number 2, that is Srimati Lal Chapui, which clearly shows that in fact the act issued by me, and it is a fact that the deceased was not on a fixed monthly salary, earning an average of 10,000 to 15,000 per month. So the claim is, the income of the claim is mainly on the presumption and assumptions.
Where is the income part?
Income is annexed at,
No, what is the discussion on the income, on the judgment?
it, and that is not being.
15,000.
Yes, Lordship. 10,000 to 15,000 per month.
So the employer has proved the income.
Yes, sir.
Heard. Notice to the correspondent steps by speed post to AD. So call for the TCR.
Lordship, I'm sorry to interrupt. However, there is an IA for stay. Since there's an execution case going on.
IA for stay will be considered upon receipt of the TCR.
17.7.
Deeply obliged.
Item 8.
Similar, Lordship, in that, in this one, we were.
All
the
right, same
amount.
order.
Yes, Lordship.
17.7.
Deeply obliged.